For local churches in 2026, the journey to a new sanctuary or expanded ministry often goes directly through federal court. While the Religious Land Use and Institutionalized Persons Act, also known as RLUIPA, has been in place for over 25 years, recent changes in the legal landscape have created new opportunities and challenges for congregations seeking zoning approval. Today, we have Dan Dalton of Dalton and Tomich, who's the leading attorney representing religious institutions such as churches, schools, mosques, and temples across the United States, is here to discuss the 2026 trends in religious land use and zoning disputes. So, Dan, the most powerful tool in a church's legal toolkit remains the equal terms provision. Courts in 2026 are increasingly strict with municipalities that permit secular assemblies like theaters, gyms, or private clubs in zones where churches are not allowed. What trends are you observing?
This new trend indicates a regulatory purpose really is at the tipping point in equal terms claims. Municipalities often argue like gyms, for example, are different than churches because of tax bases or vibrancy. But when a court looks at an equal terms comparator, what it's really looking at is the regulatory purpose. It's not going to look at taxes. It's not going to look at parking, lighting, noise, or any type of other thing that a municipality might look at to distinguish the comparator between a church. So here's the key insight. If the church or a municipality allows for a social group or social organization, but denies a prayer group, for example, or a homeless shelter or some sort of religious group from practicing their religion in a community, that is likely going to turn or lead to an equal terms violation.
Historically, some courts held that if a church could build elsewhere, a zoning denial wasn't a substantial burden. Is that changing?
So there definitely seems to be a shift away from is there any other place within the community to build for a court's analysis of whether it's financially viable to do so. So, for example, a lot of communities provide that residential zones is 70% of a community, for example. It's generally 70, 80% is generally what it is. And that religious uses are available in that 70, 80%. But the takeaway that the court's going to look at is of that land that is zoned available for church or religious use, how much is actually available to the church to use or to buy? In other words, is that land available on the market, or does the church have to go to these private property owners and collect land? If it becomes financially unavailable or not a viable solution for a church, the court's going to really kind of take away that whole issue of looking for a church elsewhere. It's really kind of gone another direction, and I think that's a new trend that we're going to see. We've seen in 2025, and we're going to see in 2026. The shift again is moving away from is there another lot to is the government's process oppressive? One other technical thing that courts really are looking at is what about this process itself that the municipality is putting the church through? You know, for in some states, in like California, you have to go through the California Environmental Quality Act or CEQA. New York has a similar statute called SEQURA, SEQURA, which requires a municipality to go through those steps. And each community interprets and applies CEQA in California or SEQUR in New York differently than another one. So the courts look at how that community applies those environmental laws or those land use laws to a religious organization to see is that really a substantial burden or not. So we're seeing a trend away from you have to apply to be denied for a substantial burden to what is the impact of that process and will that process generally will that process generally result in a substantial burden? Not every court is going that way, but we're seeing a general trend away from, you know, this whole thing of you have to go through that process when that process is so expensive and unpredictable and lengthy in time. And I think that's a new general trend that we'll see in 2026 as well.
Churches have expanded beyond just Sunday worship centers. They now function as soup kitchens, recovery centers, and temporary shelters. What are trends regarding their growth into ancillary ministries?
The trend is to expand the scope of these ancillary ministries. In the last, I'd say, 3 to 4 years, we've seen more and more denials of homeless shelters and soup kitchens and services to the general public by municipalities because they just don't want those people in their communities. But federal courts have, over time, have warmed to the idea and have embraced the idea of Christianity, for example, is more than just Sunday mornings at 10 a.m. or Wednesday nights at 7 p.m. for a Bible study. Christianity and pretty much all religions have a social aspect to them. It's providing for the widow, the poor, the orphan, the immigrant, and providing for food, for shelter, for care. And with that, the scope of RLUIPA has expanded. So we're seeing from a case called Micah's Way out in California, in Santa Ana, California, the progress of homeless shelters being expanded for cases here in Michigan, where we're working with a number of similar type of organizations to help them expand and adopt and apply and provide for the least among us in our communities. I think that trend is going to continue in 2026 as well.
A key development to watch this year is the impact of cases like Landor versus Louisiana Department of Corrections. Although a prison case, the doctrine of holding government officials personally responsible for knowingly violating RLUIPA is increasingly affecting the land use sector. As a result, local council members are becoming more cautious about making quick decisions based on neighborhood opposition. What are the emerging trends regarding officials' accountability?
The trend from 2024 to 2025 that we're going to see into 2026 is that the statements made, the emails from planning officials and elected officials, the communications made by individuals to block religious uses are becoming more impactful and more dispositive in substantial burden cases. I think we saw back in a case called Master Cake Masterpiece Cake, I think it is called, out of Colorado, where the Colorado officials were very, very antagonistic towards the individual who owned the cake shop, and their comments were part of the record. And I think the United States Supreme Court in that case found that really just to be disturbing and indicative of the culture that we're in right now. And I think courts are kind of latching onto that, where this trend seems to be that if you're going to have a personal animus against a religious use, that is going to be taken against you. So that's really resulted in two different things. One is that just wild comments out from the public and from elected officials, and with "we don't really care what you do" kind of thing, to swinging to the other side where there's no commentary. There's a public hearing, nobody says anything. There's a motion to approve or deny, and there's a vote, and that's it. That's it. And I think depending on who's the attorney, quite frankly, for the town or community that's going through the zoning issues, I think that's where we're going to see, what's happening next in this area. But I think courts really are going to latch on to those specific matters. I think really where this goes down to is proving religious exercise. There's just a fundamental disbelief by a lot of communities that a local religious organization is involved in a religious exercise. And that comes from schools, homeless shelters, things like that. I think the issue that we have and that we're seeing, at least that what I'm seeing, is that a lot of local officials bring their idea of religion and how religion works from their personal experience. And that personal experience might be just showing up on a Sunday morning for services, and that's it. But religious institutions generally are 7 day a week operations. There's Bible studies, there's schools, there's food pantries and homeless shelters. There's all sorts of things that churches do during the week that may not have been done in the past. And so when you're faced with a planning director or a planning official who might not have a church background, which is increasingly common, or has a limited church background in one parochial area or one particular church area, you're going to see a lot of these religious uses being denied because they're just not familiar with them and thinking that, church, mosque, temple is only 1 day a week for 1 hour and that's it. So I think proven religious exercise is really going to be critical in this point. The second thing is establishing these comparators for equal terms claim, and that's building your case moving forward. So that's more about looking at the zoning map and looking at the zoning ordinance itself to find out, are there comparators out there to our use where we're being treated differently than others? In some cases, you have to prove animus, which is they're allowing one religious use over another. In other cases, you don't, where a secular use, like a governmental building or a theater or another place where people get together and gather for assembly from a secular standpoint, is being treated more favorably than the use for a religious use. And that's just something that you'll have to kind of weed through and guide through and look at in that particular community you're at to determine if we have that equal terms comparator. We also need to look at demonstrating substantial burden as well. And how do we determine that there's actually a substantial burden? Again, each circuit has kind of come up with a different test. Each state has come up with a different test of what a substantial burden is. Some have swung way to the side of a substantial burden is a complete denial of your religious uses. Others have gone the other way of substantial burden is inhibiting your religious exercise. So knowing where you're at and how it's being applied to where you're at is going to be really important in this matter. And finally, the paper trail of hostility. I think that's really kind of one of those things that we're going to have to look at where you might not be thinking about there's a hostile governmental agent on the other side. We've got a case right now, for example, where we have established over time, over a period of about 20 years of three different locations where the county has continued to oppose this particular church. Wherever they try to develop, wherever they've been, where they started in a school, and the county went after the school saying that they didn't have a conditional use permit because of for religious use on a Sunday morning when nobody was using the building and they were going to shut the school down, to the county denying a particular piece of property to be built for religious use, to a county finally approving another piece of property, but allowing only half the building to be built, but not the other half that was originally approved during site plan approval. So those are the things I think the hostility to religious uses, in particularly in those regions of the country where they are more secular and less religious. I think those are the things that we have to really focus on to establish our substantial burden claims. And the trend moving forward is this animus. I think a lot of judges are looking for that. What is the reason why this use is being denied? And if you can establish animus, I think that's really important. One pro tip, though, just remember, is there is a safe harbor provision to RLUIPA. That is that if the community denies a religious use, they can fix it by allowing it later. And there is a safe harbor provision in there, and we can walk through that with you if that's something that is happening in your community or in your particular area. So if your church is facing a no, or if you have experienced a no, whether it's a church, a mosque, a temple, it could be a school, a soup kitchen, a food pantry, any type of religious type of use. Senior housing is another thing right now as well that we're dealing with. Feel free to reach out and we can talk about whether there's a viable claim here or not. There may be, there may not. We're going to tell you right at the outset if we think there is one, and we'll work with you to establish that claim through the system using RLUIPA and also the First Amendment type arguments.